You're listening to the Valley Current.
Their celebrity picture if they didn't give you consent. Now, there's all sorts of First Amendment issues wrapped up in that, but put the First Amendment to one side and ask yourself what's really going on here. I think what's going on is they're trying to define a new quasi-celebrity trade dress or quasi-celebrity dress tort, which is when a shoe is designed by a celebrity and worn by him and maybe his family of Kardashians. I don't know. Although I guess he's been stripped of the Kardashian connection because they're getting a divorce or they're separated or something. I don't keep up with this stuff, but I know
they're getting a divorce.
They're getting divorced, right? And then Kim failed the bar exam or failed the baby bar exam. So anyway,
Yeah.
my point is that there's a state law case that a state law judge that knows nothing about intellectual property might well say, well, let's see what the jury has to say about this. You know, like maybe I'm just going to allow this. And this would be like a perfect case for a writ, or almost a perfect case to try to get some sort of certified question. Is there a state law tort that's not preempted by federal trademark law, federal trade dress law, federal copyright law, federal patent law, federal design patent law, federal trade secret law? I mean, it's all published. There's nothing secret here. It would be different if Walmart stole the plans and came to market ahead of Yeezy, right? That'd be a trade secret case or some sort of misappropriation. They just bought some shoes and decide to like say, hey, we can make a cheaper shoe in a different color. It's not actually the same color. So then the second piece that needs to be studied before Friday is I sent an appellate, a Supreme Court writ of certiorari brief that was filed by a company that makes a confectionery product, essentially chocolate on a breadstick. Does everyone get that? Did people get this?
Yeah.
So this is the actual food. Are people with me? This is the actual food. Can someone find the link that I sent to that so I could put it up on the screen? This is the actual food. We're talking about like the actual breadstick with the chocolate on it. That's what they're claiming is subject to trade dress protection under the Lanham Act. And I think they even have a registered mark in that actual look. And a company, a Korean company, so it's always like a Korean company. It's almost always like a Chinese. It's always like wherever labor is cheap, right? It's always like some company where labor is cheap decided to do a knockoff. It's almost the identical case, you could argue by analogy, right? It's always almost, yeah, good, thank you.
Did I share my screen?
Yeah, good.
Okay.
Good. I'm glad you're fast on the draw. So has anyone ever had one of these Pocky?
Yes.
Or Pokey?
They're so good.
Has anyone had any of these Peppereros?
I've never had a Pepperero.
Well, my guess is if we find Pepperero, it's probably half the price. And that really hurts when you are kind of have a business and it's making, a few $1 million a month and Pockies are selling like mad. And all of a sudden it's like not $1 million a month. It's like 500,000 a month. What happened? People figured out that you can buy a cheaper version by a different brand and it's just as good. It might even be better. And so then they call their IP lawyer up. That's the first thing they do. So if you want to practice IP law, you have to be ready for what's typically a closet monopolist asking the question, how can they do this? How can they do this? We came out with this first. We came out with this beautiful chocolate confection. And if you look at the brief is really interesting because the one thing they did well, I thought, a lot of it I didn't care for the writing, but one thing they did well is they put in a table. Yeah. So now scroll forward to the table. This is brilliant. Whoever came up with this was really smart. All the rest of it was not great writing, but there's this great table right there, right there. Go backwards. Yeah, stop right there. Oh no, let's go. Is there another table too? There's a
No, just the
keep
these
going
two.
down to the when they get to the schematics. First they do pictures. Keep going. That's brilliant.
Okay.
That table is brilliant. Why? Because the message is, look, we allow all these other companies to trademark things as trade dress. Candy Kisses, Hershey's, those little kisses, those are protected by trademark law. Everyone knows a Hershey kiss. Look out what else Hershey did. Hershey was able to get a trademark on all those little, what looks like a spreadsheet, 4 steps down in the spreadsheet. If you want to say this table is a spreadsheet, if you go down from the Kiss one, people know that there's a Hershey bar that splits up into those 12 different little squares. Do people know about that? You've had a Hershey bar. Everyone's had a Hershey bar, right? I mean, that actually is famous, right? I mean, that actually is famous. That Hershey bar with the way it splits into 12, I think that has become famous. But my point is that the point that they're making is almost, we came out with this great idea, underline the word idea. We came out with a really brilliant idea. We implemented it in a way that created a trade dress that has a huge amount of goodwill. That's almost what Kanye West is saying on the shoes, except it's hard to believe that those shoes can become famous the way, say, a Hershey Kiss, right? Right? Because they're not that unique, right? They're not like a Hershey Kiss. They're not like a Hershey bar. They're not like a Toblerone. Look at Toblerone. That's interesting. Toblerone was able to register the look of, and this, by the way, goes way back to the 1950s. There's a famous case, I bet people remember, that there's a whiskey, I think, that's called Pinch. It's in a bottle that you can pinch. I'm probably really dating myself here, but do people know about the Pinch bottle? It's a bottle. Yeah, there's a bottle. This is actually what started all this trade dress. If you go backwards in time, there's a great article that Mike Risch and I did a couple of years ago. I'll send it around, that talks about trade dress in cyberspace. And it goes back to the original Pinch bottle. So I'm going to take the screen share back for a second from you. And I'm going to show the Pinch bottle, because you to understand how IP law gets developed by people coming out with something that is really unique, but can't necessarily get a design patent, or can't necessarily get some sort of copyright or something that gives some sort of protection to it. They go in a different direction, which is they say to themselves, well, could we possibly turn this into something that becomes a trademark? So if you look at this Pinch bottle, I'm going to put it up on the screen. It's actually, the company is called Haig and Haig. See, if you're from the 1950s, which I am, this bottle, which actually this is a version of it from the 1970s, but there are earlier versions. You see how it pinches? You see how you can pinch your hand in it to hold the bottle? So it's partially functional. You follow? Partially functional. It's partially enabling you to better hold the bottle. Does everyone see that?
Is this bottle only specified for liquor?
Yeah, well, they essentially take the view that their bottle is an important trade dress, and no one can use a bottle like this because the bottle itself represents their scotch. That bottle represents their trademark.
Like the bottle shape?
The shape of the bottle. The shape of the bottle represents their trademark. So think of it as they're saying we have protection in the shape of the bottle because people recognize the shape alone. They do put the name Pinch on it and they do put their brand all over it. But the trademark office has accepted this, and they have very aggressively policed others so that there cannot be anyone using this bottle. So I don't think you'll find this bottle used on like perfume or other things because they'll send a cease and desist letter. And one of the reasons they do it, and it's 100% Scotch whiskey. I was right that it was whiskey. And that's the look of the bottle from the top side, right? It's from Scotland. So think of it as people actually sell these bottles used because they're kind of viewed as ornamental, right? So this was from the 1950s. There's one here, I guess, from the 1950s, $355. I don't know if it has the actual alcohol in it too. I guess some people do keep their whiskey that long. That'd be like 70 years old. So in general, do people get what I'm driving at here? Which is that bottle would ordinarily not be subject to any intellectual property protection. But because they have so marketed it and so made it their brand, they have turned this into a trade dress that is a trademark and a registered trademark for them. Right? So Elizabeth,
How did they get around the functionality thing?
They were able to say it's not primarily functional.
Okay.
They were able to say you could pinch on two sides, but not three. It's three sides. So arguably they had to disclaim if someone comes up with a pinch bottle that's just two sides and not three, it's triangular. It's three-sided pinch. You could sort of pinch it twice. You could pinch it with your right hand and pinch it with your left hand at the same time. Do you follow? It's triangular.
Yeah.
So maybe someone with two pinches, I mean, this is where you get into what's a design around. What's a design around for a piece of trade dress? It's like a design around for something that's patented, right? So think about this for a second, because this is an important thing that's going to lead up to Friday. When you do create intellectual property, and you do create it, the typical trade is you get a monopoly in that intellectual property for a limited period of time. So in the area of patents, it's at most 20 years from the date of application. In the area of copyrights, it's the life of the author plus whatever the latest is, 70 years, some crazy number. It's a crazy, too high of a number if you ask me, but it is what it is. In the trademark area, the trade dress can be perpetual. There's effectively a monopoly on this bottle forever. There's no expiration. There's no expiration date so long as they continue to market it, so long as they keep it going in commerce, so long as they police it, so long as they stop others. And indeed, if they police it well enough, they could turn it into a famous trademark, which arguably some trade dress items are. Like, does anyone have a Mont Blanc pen? The top of that pen, which is sort of like special to Mont Blanc, has become a famous piece of trade dress. Do people know what I'm talking about? The very top of a Mont Blanc pen?
Mont Blanc? M-O-M-B-L-O-N.
Yeah, Mont Blanc, the very famous pen. Has anyone not gotten a Mont Blanc for graduation? I mean, everyone usually gets some sort of Mont Blanc.
Talking about, I think I've had one of these before.
Mont Blanc is a very famous pen, and one of the reasons for it is this. They have this top. You see it? With the little star at the top?
Oh, okay.
See that? They have a registered mark in that little star at the top. They stop people from coming up with any type of pen that has that top. So the barrel might be similar, but it can't have that top. It's got to have a different top. So they have protected as trade dress that top. Do you follow?
Is it just the white star?
Yeah, no, it's the actual top. It's the whole thing. The white star plus like the...
It's the clicky.
No, it doesn't click. It doesn't click. It's actually just
It doesn't click?
no. It doesn't click. No, it doesn't click. There's one that screws. This is the classic Mont Blanc. It's the actual fountain pen. I guess you can buy them for $685. They're pretty expensive. Right? No, they're pretty expensive, and they do keep their value. They are considered super luxurious items. These are like super luxurious, but it's got this rounded top. Can you see this?
I would get old in my house, and none of them have that.
This too, even this little circular thing, they have trade dress in that. They can't have trade dress in the pen, although I think they do have trade dress in the engraving. But the pen is kind of functional. That's the look of a fountain pen. Do people remember what a fountain pen is? You
Yeah.
put the
Yes.
pen into a pot of ink. This is really dating me. But you put the pen into a pot of ink, and there's either a cartridge or a way to suck the ink into the barrel, and it kind of enables you not to throw away an item. You're just using the ink, and then you can buy the ink separately. I'm sure, this has become a rare thing to actually have a pen with ink, but there is that approach, and it does represent kind of an old school way of thinking of trade dress. So I wanted to give this introduction because I do think those two cases, the Kanye West case and the case involving the chocolate food item, are good examples of what's not, arguably not. I think the food case is a closer question because it does look like they've been on the market for a while, and it does look like they've associated the red packaging. Maybe they should get those Korean competitors to not use red in the packaging and not use a capital P in the name, although it's a different name. I mean, what's the vote? Let's just take a vote. Who thinks that the Korean defendant is okay? Just say yes for okay and no for not okay. Okay, because the typical next call after the cease and desist letter comes in is to the IP lawyer for the defense side. I mean, we do both sides of these cases. There are some firms that only do plaintiff's work, some firms that only do defense work. We do both sides, depending on what the facts are and if we think there can be a defense. So in general, do people put in the chat, yes, no? Yes would be the defendant is okay. No, the defendant is not okay.
I'm slightly on no.
You're saying no. Okay, Max, this gets your chance to argue for 30 seconds why it's not okay.
I feel like when I argued, I'm going to get burned alive here, but whatever.
Okay,
So,
that's good.
It looks similar. It just, please roast me here. Just a little bit of doubt in my head. I'm like, they look so similar, but at the same time, they've been out for so long. I don't know why it wasn't earlier.
Yeah, that becomes a really interesting question, which is when it looks like you've sat on your rights, which is why these policing letters go out in high volume.
Tune in next time on The Valley Current.